Thanks, Ray. One of the big issues that we found in the transportation industry is whether or not to use independent contractors and what that means in using independent contractors. Wage and hour issues in California are issues that won't go away. They were a wave for a while, and we thought this is just a wave that at some point in time it's got to run out, and it's not. And one of the new issues that's really coming up are the independent contractor issues, and one of the main reasons is because most employers do it wrong. They just think if they term somebody an independent contractor, that they will at that point in time be an independent contractor. And you know, you're getting a lot of decisions from labor boards where people have termed people independent contractors where they actually are employers, and it's causing a lot of problems with the employers, with penalties and wages, back wages they have to pay, and basically restructuring their business. The labor board in California is cracking down on these issues, and there are numerous lawsuits. A lot of them are coming out as class actions. A lot of them start as word of mouth. Someone will win a lawsuit and they'll turn to other people and word will get out, and the next thing you know, you've got a class action with other employees there as well. So one of the issues we're going to talk about today is how this is changing, could possibly change the transportation industry, and things that employers and the companies can do to help make sure that if they want their drivers to be independent contractors, that they are, and how the airports and everything can help out with that. Recently, we've handled several cases for our client Rideshare Port Management. We've had some good successes there. Ray has helped out. We just won an arbitration this summer, and Ray is very helpful in explaining how the industry works, because I think that's really a key part of any litigation aspect of it, is to get one point that we always try to get across is how the industry will change if these drivers are employees as opposed to independent contractors. And we try to make the courts aware and know that if they're going to rule against the companies, it's going to have a grave ramification for the shared ride industry. So the first question is, with all the issues, why use independent contractors at all? And the bottom line is it's beneficial to both the companies and to the drivers. The owner-operators can earn more money by working when they want to work. They can get to the airport at busier times. They can, basically plan out a day where they can earn the most money. And it helps the company with operating costs. They don't have to pay overtime. There's no payroll taxes. So it is beneficial to both the industry and to the drivers. And again, this is the point we try to get across when we litigate cases, that if a judge or an arbitrator is going to come across and deem the drivers to be employees, we just try to tell them, and Ray's very good at helping us, that this could have grave implications, because you will see companies not being able to afford to continue on. You will see drivers having to drive during periods of time where there's low time at the airport. I mean, you get that shift from that 11 o'clock in the morning to mid-afternoon. They're not going to make any money. They're going to have no incentive to drive in the vans, and next thing you know, the industry is going to go away. And that's the point that we try to get across, and make any judge or jury or arbitrator realize that if they rule against the company, they might be setting the industry back. The key issue in California and in any other state really is the control. Courts look to see what kind of control that the companies will have over the drivers. And really the issue is whether the company has the right to control the details of the driver's work. And the issues that we see arising in the lawsuits are owner-operators claiming that companies telling them when they have to work, who they have to pick up, that there will be consequences if they don't do what they're told. They have to work 12 hours a day. They all come up with the same sort of stories. Oh, we're told we have to work 12 hours a day. Well, nobody tells them they have to work 12 hours a day. We're told how we have to pick up fares in the airport. Well, everyone's got a concession agreement, and they don't seem to want to give that point up. They also talk about how they're paid, how they have to maintain their vans. They're told that they have to how to treat passengers. One of the things that we see arising a lot of times is, when the new drivers come on, the companies have to do some sort of orientation, some training program, especially to drive in airports. Each airport will have a way that they want you to act in the airport, and you have to tell these to the drivers. You see a lot of drivers say, I went to the orientation and they told me how I had to do my job. And that meant they have control over me, and therefore I'm an employee, not an independent contractor. And our point is we have to let them know, and we'll get to that in a second, that this is really the airport's decision on how they drive in the airport. And it's not really us telling the companies telling them how to do it, but it's really up to the airports. Some of the factors that you'll see in determining control are listed here. Drivers like to take the position that if you tell me how to do any part of my job, I'm an employee. So if you tell me that there are rules and regulations to when I can go to the airport, where I have to go in the airport, what I have to do, I'm an employee. You know, you tell me I have to wear a uniform, I'm an employee. That's the issue they take, and that's actually a helpful position for us because a lot of times they overreach, and even judges will say, you have to have some part of control. The case law basically says corporate companies can have some sort of quality control in place to make sure that the drivers who are there are actually doing something that's not doing a disservice to their companies. But some of the factors in determining are the owner-operators acting as business owners? Can they have their own LLCs? Can they have people drive for them at certain periods of time? How does the business opportunity present itself? And that's more how you put it out there. In an ad, what does the ad say? Does it say, come work for us and, be your own boss? I mean, words like that are important. We find that what courts are really looking at is when courts see language like that, they're telling the drivers, you're on notice that when you're coming to do the driving here, that you're actually going to be your own boss at that point. Interviewing. Do you have to interview for the job? Are there resumes? Are there job references you have to do? If you have to go through an interview process, that's going to be something that courts are going to look at and say, well, if they're just independent contractors, why are you interviewing them? I was pointing out earlier today, if you're a felon in California, you can still probably drive one of the vans, so they're not doing background checks. If they do. Other factors is what's explained to the prospective owner-operators, and a writing explaining what the business opportunity is and that the owner-operators are handling their own businesses. People have to be upfront when the drivers come in to let them know these are issues that you are your own business. You set your hours. You set your times. That when they come into the door and they talk to the person about whoever it is about that opportunity, that person should let them know up front. You set your hours, you set your times. The more you work, the more money you make. The less, it's all in your control. We have certain regulations that the PUC and airports will provide, but it's up to you to make that time. Even conversations as mundane as that are things that courts look at to see that, okay, it's putting at least the drivers on notice as to what the relationship is going to be. The rules are regulations for the owner-operators, airport regulations, PUC regulations. One of the things that is an important factor is that companies not put more restrictions on than the airports and the PUC put on. Because at that point in time, it's going to be, well, if you're putting more restrictions on the drivers, then at that point in time, you are exercising control. And how does this affect the airports? Really, the airports are, in a lot of ways, and it may sound a little contradictory, very good. The restrictions on the airport are very good for the companies. Because the law is if that a city or a city entity or an airport is putting regulations and rules on the drivers, that's not going to be an aspect that the companies are putting the regulations on the drivers. So the more regulations the airports put on concession agreements, the more that they have to do, it's actually better for the companies, because at that point in time, the companies can say, you know what, we're not regulating this. It's the PUC that's putting regulations on this. The courts have been, that we've noticed, is what it says in the PUC regulations, their licenses and their permits are very important. Because it says you can't go onto airports unless you have the airport's permission, and you have to abide by the airport's rules and regulations. And then we have the concession agreements that say how they have to abide by that. And as long as the companies are, what we found, as long as they are abiding by what the PUC tells them and what the airports tell them, courts are going to say, you know, that's not control. What they're basically doing is they're complying with what the regulations are. So the airports actually are they're our friends when it comes to regulating the industry. Because at that point in time, you know, it ensures there's quality control for the drivers without having the company go on and putting these sort of limitations on people. So things that we see is they can require vans to be readily identified by color schemes and logos. They can require them to wear uniforms. They can specify exactly what those uniforms are. They can require the vans to have certain capacity. They can put in regulations about how much it's going to cost for laps. You know, whether or not you can take 2 free laps. If you go past that, it could cost you more money. The airports can put those regulations in, and it's not going to be deemed control by the company. You know, they can require training. So the drivers, they can require the companies train their drivers, as we talked about before, to make sure that the drivers are going to know the rules and regulations of the airport. You know, they can require them to wait in holding lines and put up the rules for what those holding lines are. We get a lot of drivers who will come into these cases and say, I couldn't just come into the airport. They regulated when I could come into the airport, and I can't just drive in the airport, look for passengers, and pick them up. And one of the issues that we try to get across that's been effective is these are safety measures. That this is what companies do throughout, and these are safety measures that are very important to the company. Signs that a driver is an independent contractor. They can plan their own routes. They can decide when to work. They can purchase vans. They can drive for other companies. That's something that's important too. They should be told, you know, at the beginning, hey, this is a non-exclusive relationship. Other indicators are, you know, the secondary factors. They have their own vans. They get their own GPS. They basically provide the tools of their trade. And if they can provide the tools of their trade, that's going to be another indicator that they are an independent contractor. Very quickly, a couple issues the courts have been focused on. Agreements stating whether the driver is an independent contractor or employee. What we've been finding more and more lately is that if there's a written agreement that specifically sets out that the drivers are independent contractors, that courts are going to look at those and say, yeah, you know, that's going to have some weight. The case law isn't really focusing on that, but we found that a lot of courts are actually focusing on that. Something we found also to be very effective for employers is to have arbitration agreements with their drivers. Say if there's any issues that arise out of the contract, any issues that arise out of what our relationship is, that we can, it will be arbitrated. And just two quick, because I'm running out of time, things for companies to avoid. Don't have penalties for owner-operators who turn down fares. Don't deem them as penalties. Don't talk about penalties, because that's the one buzzword that will get judges' ears or juries or arbitrators' ears up. If there are penalties, penalties equal control. Lockouts, the same thing. If they refuse fares, they do things like that, don't threaten to lock them out, because again, those will be the two main issues that we see are really would cause issues and people are honing on. If you have a third party that does dispatch, tell them, make sure, do not tell the drivers they have to pick up fares or there are going to be penalties or they're going to get locked out, because those are things, again, that courts will hang their head on. My time's up. Again, my name's Bill Stein. I have to get my picture changed because that apparently was done in a very long time ago. Might have been my prom picture, I don't know. But the ages, the years have certainly not been as kind to me as that. So thank you very much for your time.
So, good morning. I know that our panel stands between you and lunch, so if I hear any grumbling from the audience, I'm just going to attribute it to that. I have a very unique presentation today in the sense of it's going to be New York-centric. It's going to be talking about what's new. And from the role, as Matt mentioned, my 16-year sentence in government, what New York State government and other government entities within the jurisdiction are doing and how regulators impact those cases. So in New York City, most for-hire vehicles are classified as independent contractors. This is going back to a structure by which, unique in many ways, where New York doesn't dispatch taxis through changes that were made decades ago. The dispatch cabs that you would see on that Louis De Palma and Taxi with Danny DeVito, they don't take place at this time. So the dispatch services of cabs do not take place. So there are different sectors of the for-hire vehicle world that were very clear, very distinct. In New York, it's a limousine sector, a black car sector, and a community car service, a livery, that does work in the for-hire side to contribute to the modes of transportation. So for those for-hire vehicles, the prominent model is the independent operator. So we're here to talk about some of the issues that Bill's already addressed. But for the government point of view, the IRS, those folks that have been in the news every so often, and always a newsmaker when they get involved, have been prominent in getting involved in the enforcement of the rules for worker classification, particularly with independent contractors, and done so specifically in New York with regard to for-hire transportation. And speaking about what government is doing, so in order to increase those enforcement efforts, numerous agencies at the federal level are involved. Prominently, I said the IRS, the Department of Labor, the Department of Treasury are involved, and they've created state agency, in conjunction with state agencies, these task force that work and communicate with the issues of concern regarding worker classification. So in New York State, it's the State Attorney General, and that's one of the offices actually I came from when I was a state prosecutor for the public corruption and the social services fraud cases Matt mentioned. So the New York State Attorney General, like most states, is the chief law enforcement officer of the state and has extensive authority also on the civil side to enforce the rules of the state as the state's attorney. So in conjunction with the Attorney General's office, the New York State Department of Taxation and Finance is also involved in these cases. Who else? Well, the New York State Department of Labor has three components that are involved in worker classification. Wage and overtime, unemployment insurance benefits, and workers' compensation issues. And all of this is all part of the work that's part of this task force. So the question becomes, well, how far is the Empire State willing to go and will do in terms of proper classification? Well, that's why we're here. It's pretty far. It's a loaded question because since 2007, the workers' compensation law was changed in New York State to make workers' compensation violations a crime. And so, a guy you might recognize, Andrew Cuomo, who's our current governor, then Attorney General, used this law that was put in place by then Governor Eliot Spitzer, who might have been in the news recently. Basically, they took actions to criminally prosecute employers who are found in violation of the workers' compensation law. So it made news when he, in 2008, prosecuted a pizzeria owner from 55th Street in Manhattan. It wasn't the first case. There were two cases before that. This case demonstrates what happens when you're in trouble. One of the things that I was learned from the cases we investigated, and even in the work that we do as monitors for those who are under investigation, is when you're in a hole, stop digging. And we had this pizzeria owner who had committed worker classification violations, workers' compensation violations, which would have been misdemeanor, and then took the additional step as the owner of Pronto Pizza to give the State Department of Labor records that had been slightly altered. That's what we call in the legal community bad. It's a felony, and that was part of why this case made so much news and why Pronto Pizza is no longer in business. So the task force is a great deal of efforts at the state level agencies, the federal level agencies working together. But one caveat to this group especially, and to those who are in the industry, is that even though they're working together, their results and their settlements can be done individually. So any company under investigation may reach a settlement with the Department of Labor and think that all's well, but the saga may continue with the next agency coming to your door. So, in New York State, besides these civil and criminal penalties, these companies are facing private causes of action from their alleged employees, Fair Labor Standards Act violations. just as recently, I guess within the last year or two, there are two very active federal cases, class action lawsuits that have been brought against transportation providers by drivers who are making a whole host of claims involving worker misclassification and all that comes with it. And because of the federal penalties involved, these cases are being tracked closely because, as I said at the beginning, these are cases that affect the whole swath of the industry because it is the prevalent mode of work classification that is used in New York. So there are state laws regarding overtime and back pay that can be involved, and that's a class action because of the damages involved and the issues that take place is a paramount concern to both the companies and to those who are doing the investigations. So the definition from the IRS, it's as clear as can be, an individual has the right to control or direct the result of the work performed, sort of what Bill had mentioned before. So we see, and these cases tend to see in these Department of Labor hearings at the administrative level, all show the driver agreement stating, as clear as can be, this term of independent operator. And the concern is repeating something does not make it true. And this is something that the group at least should understand is where we're going is that regulators have a role here for the exact reason because New York and the issues that come up, control is the key word. Because a company engaging an independent contractor may find help from that regulator. There's a sort of a safety line, if you will, thrown out, a life preserver to these companies under investigation. Why? Well, what kind of things do you do in your jurisdictions with the for-hire vehicles? You know, Bill certainly enunciated with the airports, but are you mandating inspections, vehicle age requirements, education and training that to be current, consumer protection provisions that are going to be in place in your regulatory structure? Are there any sorts of work restrictions that you put in place? All of these are controls that may be alleged in a case, but they are a defense for that alleged employer. In fact, from one case, when going back, this is a quote from the cases, enforcement of New York City Tax and Limousine Commission regulations through provisions in a driver application agreement with the base through company policies do not evidence control by the employer, but rather constitute supervision. So it's important both to the regulator and to the companies as to how these drivers act in their capacity. But it's also important to investigators because it's part of the analysis that they undergo. If an agreement specifically addresses the driver's right to retain discretion, that's helpful. It takes away a lot of the sting of that investigative agency coming in. But discretion towards hours, assignments, withholding, the payment period, all of which will be key. Now, base imposed fines, committees to assess disciplinary action will be seen adversely by any investigator and certainly be used as prima facie evidence to say that there is control here. Is the punishment, if it's monetary, done through withholding, through the pay? Then you have sorts of labor violations at the state level as well. One thing that is come across, and maybe you've seen it as well in the cases, is when you're in an administrative hearing, much like you know your industry and understand the regulatory structure as you work through your day, a labor hearing officer is not necessarily in tune. And so we've seen over and over these transcripts where it's sort of the white noise. It's lost, where the alleged employer comes in and says, well, here's the rule book. Here is our regulatory structure. Yes, of course we say to the driver, you must not be this. These codes of conduct are prohibitive on the regulatory side, the thou shalt not. Certainly, the driver agreements could have the aspirational code of conduct. We want you to strive to be the best driver and best representative of the company. But when it's the prohibitive side, that should be a prima facie case as a defense. It is lost. You have to understand how difficult, we've seen it in the transcripts where the companies that are trying to respond to these cases are educating the Department of Labor and other hearing officers as to what this industry regulates and how. And the idea of consumer protection and the bases that is very rational and supports your regulatory structures is sort of lost in some ways on it because all they see are the claim made, factually so, and well so, that they're being asked to do quite a bit. And so it's an important educational tool to look at the regulatory scheme, and that's how the regulators get involved. Now, you might know that there's some apps that have become involved in the transportation world. I think that was the number of apps and icons as of 12 months ago. It's probably a little more now. So we're seeing innovation, technical and otherwise. The transportation industry, if you'll excuse the pun, rolls on. And so you see that apps have come in to be a key participant and role player in the world of the transportation industry. So what is new with the smartphone apps? Well, welcome. The new world is meeting the old labor obstacles as well. The app companies are now facing class action lawsuits most recently with regard to how they do business under their terms of service. So there are 2 cases in the United States District Court for the Northern District of California, based out of San Francisco, right out of Silicon Valley, where in the last 6 weeks, 2 cases have been prominently filed. The first is against, it's been filed against Uber by 2 drivers claiming a class action. And what they're bringing is a national lawsuit. What they're saying is, in their suit, that Uber is retaining, as the company, is keeping 1/2 of the gratuity. And who knew? California has a California gratuities law that states that the recipient of the gratuity is to, in state law, receive 100% of that gratuity. So the claim is, A, 1A, Uber didn't pay the full tips to the drivers, or B, the company, the drivers do not receive the tips because the terms of service are stating to the customers tips are included. The second cause of action is that the company should pay the drivers for the business expenses of the vehicle, gas and other costs. So as you could see, because of the volume of the industry, if you do this over a course of a nationwide lawsuit, it gets to be real dollars. So that case was filed on August 16th, and it's in the early stages. The questions are going to be very clear, laid out in the claim. Whether the company charged passengers a gratuity, whether the company failed to distribute the total proceeds, whether the drivers had informed customers that the gratuities are now included in the price and what that means. Did the drivers have a reasonable expectation of receiving tips? And lastly, getting a 2-minute hook, okay? And then the damages to the drivers for those. So it's going to be, and the separate question of the reimbursement of expenses, again, real dollars. 2 weeks later, the beginning of this month, in that same district courthouse, a driver for Lyft, the ride-sharing program, brought suit, again, in a federal class action, stating that Lyft is misclassifying its drivers and has created or had labor violations. What's going on? So the Lyft driver, who's the lead plaintiff right now, and it's going to wait for class certification, is alleging that the average gratuity payment is $15 per fare. And what he's saying is, since Lyft has dispatched 1.5 million rides, you could see the numbers already getting to grow very quickly. So what's happening? The drivers are providing a service. And they're saying, well, Lyft can terminate the drivers without explanation. Lyft can terminate the drivers if they're behaving inappropriately. And Lyft is taking 20% as an administrative fee, but yet if it's termed a gratuity, under state law, they're saying we should get what percentage? 100. So they're asking to be made whole. This is, as I said, very relatively new case, only a couple weeks old. It's going to work its way through the system. And the driver's saying, if this is the situation and we've misclassified these drivers, we seek reimbursement for the costs incurred by drivers who use their own vehicles. And that's what they do. They use their own vehicles. So the fact of the matter is, they're speaking to the bottom line of being, is this a case worth at least $55 million in diversity, and they are laying out the facts. So I don't speak to the merits of what will happen. These are relatively new cases, but it's what's new in terms of the app world that is besides the world you live in terms of the regulations and how to understand and deal with app companies and technical and innovative changes in your jurisdictions with regard to apps and other technical and innovative changes that occur as the nature of the business works. So that's my contact information. Unfortunately, that does look like me. And I'm very grateful, and I guess Andy Warhol was right, my 15 minutes are up. Thank you very much for your time.
you're getting your stair-step exercise today, like it or not. The National Labor Relations Board is what we all fear at this point. To the extent that the NLRB can come after anyone who's operating any kind of a business anywhere under the sun, it is the most criticized agency at this point. As an apologist, I used to work for the board, and my firm, a majority of its members used to be with the board, one of which used to be a board member. Our firm apologizes for it and then tries to at least give you some indication of where it's going to go. Left, right, ahead, yes? Yes. Brief history of the National Labor Relations Board goes back to the 20s and the 30s. It's there to protect employees. They do have a specific provision that says independent contractors are not covered by it, and that's been the tectonic plate shift grind ever since. Section 2.3 of the NLRA, if you want to look it up in particular. But the key is the NLRB makes that decision, and makes that decision based upon a huge number of discrete facts. It is fact specific. As Bill and Pat both mentioned here today, those details, the devil is in those details, and those details are extremely important. Perhaps we should not be ending with me, because instead of being hungry for lunch, you may have indigestion right away. The Supreme Court has weighed in on it. The NLRB's gone back and forth on it. And way back in the last 10, 15, 20 years, the ebb and flow has gone back and forth over this generic term called the economic reality test. And the NLRB can define independent contractor any way it wants, because it's that board defining it at that time. And it's based upon that particular decision. Do they look at precedent from time to time? Sure. Do they then abuse it? Absolutely. If you look at how they have defined over the years, they've gone after a few particular contractors. And one of which was, if you remember, DHL used to have a large domestic operation here in the United States that it operated on, and it just made the decision at one point that it's too expensive to even fight the issue. So DHL on one day in November a few years ago just closed down some 16,000 jobs nationwide as part of its domestic operation. It still has the international operation, but DHL just gave up. FedEx is still plodding along. And remember why. FedEx has a different model than UPS. And if you're wondering most recently about this slide talks about the current crisis within the National Labor Relations Board as to what's happened to the decisions over the past 2-3 years. The past 2-3 years of the National Labor Relations Board, there's a challenge pending in the courts, pending at the Supreme Court now, as to whether or not there was a true quorum. The true quorum test is whether or not the Senate was ongoing when the President made certain interim appointments. If the President made those interim appointments improperly, then, and the Senate was in session, then those interim appointments are invalid. That's what the Supreme Court's going to be deciding in the next several months. If that's the case now, however, even if those cases then come back to the National Labor Relations Board over the last 3 years, you have a fully staffed National Labor Relations Board at this point. And it was a compromise reached in the Senate. Is anybody here from Louisville? Well, part of the reason some suspect that there was that compromise to allow the National Labor Relations Board to be fully staffed at this point, and there was no longer going to be a press within the Senate to oppose that, was the fact that Mitch McConnell's backyard there in Louisville, the largest employer in Louisville, is UPS. So the Teamsters, having a large influence within UPS, clearly wanted a fully staffed National Labor Relations Board, and they got one. If you think of it from a big picture standpoint, and just step back for a moment, what drives the National Labor Relations Board is someone complaining. So if there's a particular union that's going to complain, or a particular union that wants to organize the drivers, whoever they may be, the independent contractors, whoever they may be, that's because someone got dissatisfied. Someone got disgruntled enough to seek someone to go to the National Labor Relations Board on behalf of their co-independent contractors. And that's where the action's going to be. The Supreme Court's going to face this Noel Canning case and then decide if there was a true interim appointment or if there wasn't, and that'll all be in the next couple of months. You can read that about that in the newspaper. The current board staffing is up here. It's in the PowerPoint if you want to check that out later. The two things that are also pending, that if you do have any potential exposure to National Labor Relations Board rulings, the two things that are out there that are coming down the pike now that the board is fully staffed includes this ambush election concept. Historically, if a petition is filed, there's a 42-day period from the time the petition is filed to the date of the election. That 42 days is going to shrink now, somewhere down to less than 30 possibly. The Canadian model is far shorter than that, and the National Labor Relations Board here thinks that, well, why don't we go to that Canadian model, have an election within 10 days after the petition is filed. So if you're going to do some education with any of your independent contractors to encourage them and perhaps help them become educated as to why a union just is going to suck out dues money and take 2% of their earnings, whatever that case may be, you may want to do that now in advance of the actual events, but that's down the road. Those are more stuff on the ambush election. The notice posting rule got struck down by the Court of Appeals last year, as well as the District Court up to the Court of Appeals. And so there's no requirement at this point by the NLRB that every employer have a notice posting somewhere in the garage or on the bathroom wall somewhere. That's dead right now for the time being. Another decision by the National Labor Relations Board recently, this past current board, provides for what they call micro units. So let's say everybody in this room is part of the employee complement. The union can come in and cherry pick table 1A and just have cherry pick table 1A so that those two employees, remember it takes two to tango, those two employees are now part of their union. So let's say you did have a group of truly independent contractors, of which most of them were engaging in this independent entrepreneurial activity, but two of them are weak. They're spineless, they don't do a job well, they don't really carry off the thing well, they don't like to communicate, they can't communicate, and so they go out and try and form a union. If they go testify to the National Labor Relations Board that they really don't feel like they had a chance to negotiate that agreement, that independent contractor agreement that was discussed earlier, if they didn't think that they really had a chance to do well and they've been criticized and they've been, quote, disciplined and they've been, quote, counseled and they've been, quote, penalized, all those things add up to the National Labor Relations Board saying, well, at least those two employees can be unionized. So even if you had a group of independent contractors, for the most part, that majority won't prevail over the group that isn't quite up to snuff with regard to that. So make an effort to make sure that all your people are independent contractors if you're doing that. Oh, these are just some of the rulings that the National Labor Relations Board has reversed in the last couple of months, last year or so. It used to be when a contract expired with a union, you also as the employer could take economic action and no longer collect dues and pass those dues on to a union. Well, the National Labor Relations Board says that's unfair. You've got to keep collecting the union dues money because the union's an important part of American society for some reason. Another case indicated, another case overturned some 35, 40 years of precedent too, that in a union investigation, you can no longer take a set of statements that are given to you in confidence by someone who's afraid of what that grievant or that terminated person would do. You have to turn those over to the union, even if there's potential threats involved. And likewise, if you're conducting an investigation, you can't tell any of the, quote, employees, remember, not independent contractors, but employees, because that's what the NLRB covers. You can't tell employees that, wait a minute, this is really confidential, and we trust that what we talk about here in this room today is confidential. That's out the door. You can't use the word confidential or ask your employees to keep things confidential in investigations anymore, because they're entitled to engage in concerted activity for the mutual protection under Section 7 of the Act. So that's a brand new rule. Good luck having investigations. So the first person you tell, look, we're investigating the theft of $1,000, boom, goes out and everybody else knows about it right away. Or the first person you ask who had access to that money, everybody knows about it right away. So finally, by the time you bring in anybody at the tail end of that investigation, they're going to know the who, what, when, where, and how of how to lie to you and not tell you what's going on. Which then brings us to a couple other decisions. Well, this is more of the detail with regard to how you're supposed to conduct investigations by the NLRB. And all of this obviously plays into why what Bill and Pat were saying is you really want to use independent contractors correctly. You really want to move towards that model if you possibly can, because it's becoming more and more difficult to, quote, govern and manage if they're just employees. You can't have a blanket rule prohibiting discussions of ongoing investigations. Anything you obtain can't be confidential anymore, and that goes on with that. Then there's another one, and this goes back to the slide that Pat just had up there with regard to the apps. Everybody uses social media. I'll just give you the facts of the case real quick. 5 employees working for a company called Hispanics of Buffalo. 4 of the employees are really not liking this one employee. This one employee doesn't like the 4. And the one employee thinks the 4 are lazy, shiftless, not coming into work, not doing their job, and otherwise just seem to be not right for the overall operation and purpose of the mission of the business. So those 4 employees realize that the other employee is about to rat them out. So those 4 employees get on their Facebook and Twitter, and they use the C word, they use the B word, they use every kind of critical abusive terminology toward this one employee. So the one employee sees it, goes into management and says, look, I'm being sexually harassed at work, I'm being sexually criticized at work, all kinds of abusive terms are being used, it's in violation of your policy prohibiting all sorts of things and requiring respect in the workplace. This is terrible what they're doing to me. Sure enough, the employer calls the 4 in and says, look, you just can't do that about a fellow employee. That's wrong. It violates our policy. It's wrong. You're all terminated. So they all run down to the National Labor Relations Board. The National Labor Relations Board said, wrong. Those people are engaging in protected activity. You can't do that to them. You got to put them back to work with back pay. Why? Because they were concerned about the potential discipline that would be resulting from the one employee potentially ratting them out. And so they're engaging in protected activity by joining together and criticizing the employee for ratting them out. So that's the National Labor Relations Board right now. A little goofy, but there it is. Oh, and by the way, that conflicts directly with what the EEOC has said with regard to investigations. The EEOC says if someone comes in, and it's in the regulations by the EEOC, the EEOC says if somebody comes in and complains about sexual harassment, racial harassment, religious harassment, any kind of harassment, you're supposed to be treating that with confidentiality. Yet the current National Labor Relations Board said, no, you can't use that word confidential. You can't tell anybody they got to be quiet about that investigation. You got to let all the employees talk about your investigation and what you do and how you do it. So it goes on forever. What do we have here? Oh, back to your point, well taken, about arbitration agreements. If you have arbitration agreements, those are wonderful, except the National Labor Relations Board thinks they're mostly invalid, just so you know. Current NLRB, okay, independent contractor of the future. If I can get to it quickly, that's the historical. The advice memorandum that was issued by the National Labor Relations Board end of May, early June, in Super Shuttle of Los Angeles. Really, if you get a chance to read that, and I'll send it to you if you send me an email. If you looked at in juxtaposition with the decision by the National Labor Relations Board Regional Office in Denver for the same company. In the Los Angeles decision at Division of Advice, Region 21 of the National Labor Relations Board found that there was a true entrepreneurial activity going on and that the unit franchise agreement was being signed by everybody. They didn't have that evidence in the Denver case back in 2010, and that's why the Denver case was decided differently. But this recent decision by the National Labor Relations Board in Los Angeles is really good as a model for purposes of going forward. If any of you are ever looking it up, really good. Again, if you compare the operational model of UPS and FedEx, that's again why the fight is going back and forth. FedEx was originally primarily an air transportation company that then became ground transport, so their guidelines are formed under the Railway Labor Act. United Parcel is the National Labor Relations Act gone into the air, just the opposite. And those two approaches have been where the big arguments have been. Okay, the UPS and Teamsters, you know about that. Other recent examples, and then I'll end on time. Frenzius was a case, 2012, I know it's small print. The employee goes out and engages in threatening and sexually abusive and harassing behavior towards a coworker in the break room, writes some terribly nasty, offensive, and obscene things on a piece of paper. The employer conducts an investigation and asks the employee, is this your handwriting? You're the only person in the room at that time, and the note was left behind for the woman who then saw it. The employee then lies and says, that wasn't me. I had nothing to do with that. The employer then later uncovers the fact that it was the employee's handwriting, that the employee did write that. So sure enough, the employer then terminates the employee for the lack of truthfulness in the investigation, for lying. The National Labor Relations Board said, well, wait a minute. The employee was also engaging in potential union activity. So based upon that, the employee is entitled to lie. And that lie can't be used by the employer to overcome the level of protected activity by the employee, so put them back to work with back pay. Okay. Isn't that great? Okay, I got another one for you. You really want some more indigestion? I'll wrap this up. Quad graphics. Employee comes in wearing a baseball cap. The employer says, look, we provide you people with baseball caps. We give them to you. We buy them. They're fresh. They're clean. Don't wear that non-company baseball cap. The employee says, I'm entitled to it, and my friends are entitled to it. The NLRB says, employee wins. Next one, Almo Products. Mr. Law Judge. Oh, employee comes in to work one day with the word slave, all in caps, written on his shirt. Okay? The employer says, look, I got a mixed racial workforce here. I don't need that in the workplace. Some people think that's offensive. Other people think it's pejorative in other ways. Just don't wear that shirt in here, okay? National Labor Relations Board says, wrong. The employee's entitled to wear that shirt. Okay, here's the next one. Employee comes into work one day. She's wearing a hat because she had a bad haircut, okay? So she's embarrassed about her bad haircut. The employer says, look, you can't wear a hat in the facility. She says, wait a minute, I'm going around to take pictures of other people who have had wearing hats. And the NLRB says, that's wrong, you can't pick on her because she's trying to prove that the rule is enforced differently among other employees, so back to work with back pay she goes. These are just some of a good multiple dozen of cases that the current National Labor Relations Board and its most recent predecessor have issued. And it's all fact-specific, and it's all gurgling up from the ground, so to speak, because there's opportunity here to satisfy a current mood within our national body politic to actually have this kind of intrusion in the workforce. So if you really want to avoid this stuff, go for the independent contractor model because it makes great economic sense. If you want to continue to fight this battle, good luck. It just is going to get worse because the current National Labor Relations Board is looking to do more. And as they do, it really won't stop. It really won't stop anywhere. So with that, I wrap it up. Enjoy lunch.